So I would like to begin tonight by thanking Professor Babcock for not only being my faculty advisor, but also for helping me to discover my ability to write. Professor Cisneros and Heather Veronini for being amazing editors, last year's Law Review Board for believing in my note, and my family and friends for all their love and support. Miranda rights are arguably the most famous words in the justice system. They make appearances on television and in the movies. Despite their use as catchy dialogue on the big and small screens, these warnings actually have an important purpose. And this purpose is to safeguard a person's Fifth Amendment right against self-incrimination. These warnings are supposed to be read to a suspect who is in custody before the person is interrogated by law enforcement. Most likely, we have all heard these warnings and can comprehend what they mean. But is that true for minors, especially those who find themselves caught in the confusing and intimidating criminal justice system? Can a minor really understand the looming consequences of waiving these rights? These are the questions that came to mind the first time I read the 2016 Ninth Circuit case, Reyes v. Lewis. This case involved a 15-year-old high school freshman named Adrian Reyes, who was found guilty of first-degree murder. In this case, the Ninth Circuit found that the police officers who interrogated Reyes used an unethical and unconstitutional two-step interrogation procedure. This two-step interrogation method occurs when police initially interrogate a suspect without Miranda rights until the interrogation has produced a confession. Then, after obtaining a confession, which is generally inadmissible because the suspect was not read his Miranda rights, the second step occurs when the officer eventually reads the Miranda rights, and then the suspect provides a second confession, usually with ease because they just confessed prior to the Miranda warnings. This is known as a Siebert analysis, arising from the United States Supreme Court case Missouri v. Siebert. By holding that the officers used this two-step interrogation process and violated Reyes's Miranda rights, the Ninth Circuit focused on a procedural issue. Ultimately, the court reversed and remanded the case, finding that as the officers employed the two-step interrogation method, Reyes' second confession should have been suppressed. Although I agree that the Ninth Circuit correctly found a Siebert violation, I believe this case could have been used to address whether or not Reyes, because he was a minor, actually understood his Miranda warnings. The issue of minors and their comprehension of Miranda warnings is often overlooked because judicial prudence asks for a narrow interpretation of the Constitution, meaning that the scope of a judicial decision is narrow and limited to the present facts, so judges are not just creating general rules. However, the Ninth Circuit in Reyes v. Lewis should have addressed minors and their understanding of Miranda warnings because the facts suggest that Adrian Reyes did not understand what the consequences would be for waiving these rights. And he is not alone. My note provides a general background about juveniles in the criminal justice system and how over time, legal standards for minors have continued to narrow. Then it discusses how the Ninth Circuit missed an opportunity to address whether a minor comprehends his Miranda rights, given that the standard for measuring a minor's understanding is 38 years old. The standard needs a modern makeover. My note also examines how cognitive functions in adults are different than those in minors. Scientific research has shown that the average brain does not stop maturing until 24. As much as we'd like to view them as such, minors are not miniature adults. Not only does scientific evidence show the difference in brain functioning, but also as a society, we have labeled them as a protective class. We set social limits for minors. They are not allowed to vote, serve on juries, watch movies with adult content, drink alcohol, or enter into contracts. Yet despite these limitations, minors are generally treated the same as adults when they are arrested, interrogated, and read the standard Miranda rights. Often Miranda rights do not protect minors from self-incrimination. In fact, minors are susceptible to false confessions. They mistakenly believe that if they tell the officers what they want to hear, albeit a false confession, the sooner they can go home. Although I argue that the Ninth Circuit missed an opportunity to address the issues of minors and Miranda warnings, the judiciary is not the only branch of government available to respond to this matter. State legislatures can play an important role in addressing how minors receive Miranda warnings. My note examines how different jurisdictions throughout the United States have approached this topic. For example, state laws in Colorado, Connecticut, and Maine require a parent attorney or custodian to be present when a minor is faced with custodial interrogation. Even here in California, the legislature has recognized that there is a discrepancy with minors and Miranda rights. In 2016, the California Senate tried to pass Bill SB 1052 that would have enacted a section of the Welfare and Institutions Code to require a youth under 18 years of age to consult with legal counsel in person, by telephone, or by video conference prior to a custodial interrogation and before waiving his or her rights. After this bill passed through both houses, Governor Brown vetoed it, stating he was not prepared to put this law into practice because of potential ramifications. However, the California Senate did not stop operating until I could finish writing this note. It responded to the veto of SB 1052 by drafting Senate Bill 395. In October 2017, just 3 days before my note went to publication, the governor actually passed SB 395. This bill requires that prior to a custodial interrogation and before minors, at least those aged 15 years or younger, can waive their Miranda rights, they must consult with legal counsel by phone, in person, or by video conference. Although this is a major step for some minors, this only affects those juveniles who are 15 years old and younger. In order to protect the rights of all minors in California who find themselves entangled in the criminal justice system, further action is still required. Thank you so much for listening. Now, please join me in welcoming our next author, Natalie Lacasille.